Good afternoon, all. This application hearing is in the matter of CFI 003-2025 and is being held by way of video conferencing before His Excellency Justice Sir Jeremy Cooke, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Afridi and Angel. Lead counsel is Mr. Mark Rainsford, KC. The defendant is represented by Davidson and Co., and lead counsel is Mr. William Frainbell, KC. Thank you, Your Honour.
Thank you very much. Yes, Mr. Rainsford.
My Lord, may I attempt a little housekeeping just to start with? May I check that your Lordship has received Owen Connolly's fourth witness statement that was filed yesterday, and the registry were asked to pass it to your Lordship?
Yes, I've read that this morning.
Thank you. And as far as the bundle is concerned, the one that I have, and I assume my learned friend, Mr. Frayne Bell, is working from, is different in pagination from the e-bundle, which has put its own first 5 pages into the bundle, and therefore what would be page 666 for me would be 667 on the portal.
And we often have this problem. Let me tell you what I've done. I've downloaded a PDF that has 701 pages to it.
That sounds very promising. Could I just ask to test this by going to page 62, and if it says Appendix B at the top, the updated payment settlement, July 2024, well, we're all working from the same bundle.
'62 says Appendix B, the updated payment settlement.
Perfect. Thank you. And could I just check Mr. Frayne Bell is working on the same?
I'm the same. Thank you very much. Page 62, Appendix B, updated payment settlement dated July 2024.
Perfect. My Lord, it rather sounds like if you read the fourth witness statement, your Lordship has read the papers, which is exceedingly helpful. Could I just clarify that?
Yes, indeed I have. So I've read I've read the pleadings, I've read the witness statements, and looked at some of the background material. 2 questions occur to me at the outset. One is whether we need to be arguing about counterclaims and admissibility of witness statements, or whether we can take all that for granted and carry on regardless.
Well, as far as we're concerned, there are 3 applications. The first, obviously, is for the interim immediate judgment and alternatively payment on account. Then there's the witness statement 3, but my learned friend and his team do not object to admissibility of that. There's then the application to amend the defence and counterclaim. And my request at the beginning was going to be, may I address the court as to why, right at the core of all of this, is the issue of whether there is any merit at all in the defence, whether it's called a defence, an amended defence, a counterclaim. It's all wrapped up as one.
I can't see any point in worrying about the question of amendment, because broadly speaking, what's in the defence and counterclaim is what's in the witness statement in any event.
Yes.
So one's got to grapple with that, and the question is whether or not you're going to be entitled to summary judgment regardless of whatever the evidence shows. So to be frank, my inclination is simply to say yes, leave to amend defence and counterclaim, albeit late, and all lots of points being taken about that. But the reality is that one has to grapple with what's there on the evidence in relation to the application for summary judgment.
Could I ask that your Lordship consider deferring whether to grant leave,
if you like,
until you've heard the arguments? You won't hear any procedural argument about whether it should be done or not. It's all going to go back to that one point, the merits.
Well, I understand that. If you make your point good on the in relation to the merits of the factual situation, then and get summary judgment, it may be there's no point whatsoever in having the counterclaim in. But there is another possibility, which I was good. There was another possibility, which was the second point I was going to ask you about, which I don't think anybody has so far mentioned. But that arises out of paragraph 1.44 of the Master Services Agreement.
Yes.
It's at page, I think, 107, probably.
Give me just for one moment.
And the relevance of it will become immediately apparent if I've
yes
understood the position.
Could we look at page 32, my lord?
32 you want to look at?
If your lordship pleases. It's just that all my MSE contract is all marked up.
Yes, okay.
And
yeah, well, there you are. Look at 1.44.
Yes.
The customer may not withhold or set off any payment from any fees due to provider. 1.45. If the customer acting in good faith disputes any portion of a fee that provider invoiced, the customer must nonetheless remit to provider full payment, blah, 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 and provide on or before the original due date a written and reason notification disputed part of the fee. And
yes,
my question was, if that is of application to all or part of the claim, then on the face of it, you might say that you're entitled to judgment on the claim, and any question of counterclaim could be left over to be pursued by Mr. Frayne Bell, should he then wish to do so.
Well, thank you, my lord. You foreshadowed one of a number of points I was about to make, including that there was no notification ever given about any complaint prior to the defence. And in fact, the WhatsApp messages, I don't know if your lordships had a chance to look, are very compelling contemporary evidence that the real reason wasn't won't pay, the real reason was can't pay. And they were grappling around trying to find money to pay the salaries for their very considerable number of staff. And that's apparent from the WhatsApp messages, which are quite stark and startling at times, but never once any message about, well, there's poor performance or misfeasance of some type. And that's not surprising, because it's clear that the draft IT review was inconclusive. There was no accountability for it. It's not clear who did it, but the two people who are mentioned most, the CIDO and the whistleblower was dismissed in February 24, and the chief technical officer was left. He resigned, but not entirely of his own volition, in February 25. Sorry, it was May 24 and February 25. But there's clearly been no update of the position in the last 12 months, and one would expect that there would have been if this was a serious internal investigation being conducted properly. But they didn't even interview Owen Connolly, who was never given a chance to answer any of these allegations, and therefore it's not surprising that he was quite upset and wanted to put these WhatsApp messages in, even though they were being discussed informally, and he'd probably rather not have done that. But he was left with no choice when the president of GFC didn't correct the false picture that was being presented on behalf of the defendant, that there'd been wrongdoing on the part of 7CI, when nothing could be further from the truth. And there's absolute compelling evidence of that. The email of the 27th of September 2024.
Yeah, the termination email.
Yeah, I mean, they talk about a good conversation, about budgetary constraints being at the heart of the problem. And if we're going to pay on time in future, we have to pare down the offering. But at page 46 is a scope of work that accompanies that email that's at page 42. May we start at 42 anyway? I know your lordship's got it. But it refers to, thanks for that good conversation. This is the head of IT, the one that was later apparently dismissed or left, not of his own volition. He refers to a new scope of work, which I'll come to in a moment. And they're offering a document that they'd like feedback on, the defendants, about which services are going to be included. And it's in the scope of works document, and they want to know what can be adequately provided by 7CI. It then goes on to say, we're likely to be very prudent in delineating the final scope of work for the new contract, commensurate with the budget availability at a corporate level. Now, obviously, budget availability at a corporate level is right at the heart of the problem here. And this will help with ensuring timely payments, considering that the plants and sites have indicated a paucity of budget available for 7CI services. The new contract will not include the CISO services. It then refers to the 90-day notice period, which isn't being admitted, but is clearly being acknowledged there in that letter. So please, my lord, turn to page 46. This is a scope of work document. Now, what's being envisaged here, and the heading is expected responsibilities and deliverabilities of 7CI. It's in table 3.1, information security strategy planning, second line, timely execution of any contracted info spec projects and initiatives. And then on the next one, 3.2, implementation of various security controls such as technical administration, administrative and physical access control systems. And on the left, establish resilient security infrastructure and effectively mitigate threats, maintain confidentiality, integrity and availability of data, and ensure compliance with the relevant regulations. Now, the question arises, if 7CI had been ripping off GFC Alliance, would they seriously, at this sort of level of seniority, have continued discussions going right up to presidential level with Owen Connolly, who was at the heart of the alleged wrongdoing, contemplating services that protect the corporate from hacking in a climate where one of their greatest existential threats would have been being hacked? I mean, their first threat is probably insolvency. Their second is attack from hackers who could effectively do what they did to Marks and Spencer's. You wouldn't trust a company that you thought had a shadow over them or a cloud over them because of what a whistleblower had said. But the actuality is that the draft reports, and they were nothing more than that, weren't signed. There's no authorship, there's no accountability. It's inconclusive and limited, and it even acknowledges that within the body of the report. It's done by the IT function and not independently by lawyers, has never been substantiated, isn't updated, and isn't actually, in my respectful submission, worth a row of beans. And then when it's looked at that it's not been pleaded previously and never raised prior to the defence being filed, it's utterly unsustainable and utterly devoid of merit. I was going to take your lordship through a quick whistle-stop tour of the contracts. There are three of them. One of them, the COD from May 21. The commercial terms are at page 17, and it's 15 days from receipt of the invoice. I seem to be getting feedback. I don't know if your lordship's getting that as well.
Very little. It's not troubling me at all.
Very well. I'll carry on.
Page
I'll mute
17.
myself. I'm so sorry.
Thank
I
you.
don't think it's me, but I'm trying.
Page 17, my lord. The first page is, I believe, page 10 of the COD.
This is the one that's enlarged, has to be reduced to read it.
Yes, that's right. It's page 10 at the top right-hand side. Proposal for COD services, dated Wednesday, May the 12th, 2021.
Yeah.
And at page 17.
Is this is not said to be a contract by the defendant, is that right?
Well, it's said not to be, but if one looks at page 18, it's been signed by the chief executive of one company and by senior people at the other, acknowledging the terms. And then the commercial terms are at page 17, payment 15 days upon receipt of invoice.
Yeah.
There's an invoice at page 55 raised on the back of that agreement.
It's signed by the big chief.
By the big chief, yes, it is.
By
And
Mr.
that's at page
Sanjeev.
18, yes.
Yes. Can I just ask this? This company, Liberty Steel Group Holdings, EMEA, where does it stand in the whole structure of the Liberty Group? Is it the ultimate holding company of all the Liberty Group?
It appears to be, and Sanjeev Gupta is actually in the email threads. I've noticed quite a few of the times, and there's reference to asking him to make these payments. Sorry,
they're very well known in the steel business, and I've had other matters involved with them at one time or another, and their current position is absolutely plain from international newspapers. What's going on in Singapore and in London and Australia and so on and so forth. But what I had understood from looking at some of the material was that this security setup was for worldwide and not just for particular regions, because there were regional IT people and so on and so forth involved. But I just like to be clear about that. It probably doesn't matter ultimately. I just want to know how central this company is to the whole setup.
There are quite a few references in the papers to the services being at a corporate level.
Yes.
Including going back to that letter on the email on the 27th of September. In the WhatsApp chat, the speak is of money coming from India, from Australia, from New Zealand at one stage. The corporate is drawing in cash from around the world to prop itself up in Dubai when it needs to. And it seems that Mr. Gupta himself has his fingerprints all over this contract. He appears in the email threads, and when they're negotiating for a new contract, he seems to be involved at that stage as well, even if just watching. I would say that it is right at the heart of it. And one of the relevance of that, the relevant features of that, is the fact that 7CI were trusted, even in September 24, to provide services at a corporate level, notwithstanding the complaints by a whistleblower that had been made in March 24, 6 months earlier, and notwithstanding the IT review on the 29th of May 2024. And we would submit that it's inconceivable that the senior management of a corporate of this size would trust an IT company to keep it safe if it had any questions at all over the veracity, over the verisimilitude of the people and the organization that they were asking to continue providing services to protect them from cyber threats. There's then
you're going to take me to this. Going to take me to this contract.
Yes, the MSA. I was going to start at COCD, which I was going to explain that the terms, which one can see at page 17, 15 days after receipt of the invoice. The invoice at page 55 was raised and no complaint ever made about it, except that it said that it wasn't received on the 20th of January 22 or thereabouts, being the date on the invoice, and wasn't received, according to Paul Francis, until September 24 on the 20th. But it would have become payable 15 days later. No complaint was ever made about what was in the invoice. And in fact, given when it was in January 22, it predates any of the complaints made in any event. It was, if there was an oversight, and it's not admitted that there was, if it wasn't received till September, it should jolly well have been paid 15 days or less later. No explanation for non-payment other than, you know, the WhatsApp chat where there's cash flow problems. No suggestion in writing or otherwise of underperformance or wrongdoing on behalf of 7CC, the 7CI, the claimant. And if we could turn now to page 22 of the bundle, there's a proposal for Sentinel-1, which
Can I just stop you a minute? Can I just stop you a minute, Mr. Rainsford?
Yes.
The monthly figure is 240,000 as dirhams, 80,000. Monthly rate.
It's a quarterly. I think. Let's have a look.
But it says payments monthly in advance. Payments monthly in advance, 15 days after receiving the notice.
Yes, they're all in advance across the contracts.
80,000 dirhams. The invoice that you're talking about is for how much?
It's 252,000, and the reason can be seen in the body of page 55, which is it's quarterly in advance for December to February, December 21 to February 22. And the reason that this had to be in advance was because it's for 21,000 endpoints or licenses, which is obviously a very expensive acquisition for 7CI.
And the reason for the figure is there's is there VAT on top? Is that the explanation?
Yes, so that can be seen at 5% in the body of the invoice. It's 12,000.
Yeah, exactly. Yeah, that fits then with the 80,000 a month.
Yes, thank you.
Got it. Yeah. Thank you. Yes. Sorry, forgive me if I keep interrupting, Mr. Rainsford. It's always a problem, particularly on when one's on a Teams call, but it certainly assists me, even if it doesn't assist you.
Well, I'd rather be interrupted and try and assist if I may. So thank you, my lord. So the contractual relationship kicked off with the provision of 3 consultants under the COD agreement, so-called. And then in October 21, about 5 months later, the S1 agreement came into being. And that's at page 22.
Yeah.
The need for that was the provision of those 21,000 licenses for staff at GFC. That in itself goes to the issue of, was this at corporate level? Because of the sheer number of licenses needed. That would indicate at a global level. And then at the top of page 25 are the commercial terms. And the quantity is 21,000 units. And there's an interesting legend just under commercial terms, which is the pricing has been based on a total quantity of 21,000 endpoints. Please, could someone turn their microphone off, because I'm hearing myself twice. Forgive me, my lord.
Well, if I turn myself off for a moment, it may help you.
I don't know who it is, my lord, but the pricing has been based on a total quantity of 21,000 endpoints as per best estimates from IT. Now, one of the complaints made by the defendant is that there was an oversubscription that was completely unjustified. And obviously, when that's taken together with the suggestion that they were making an improper reward of about 10% on the contract, whether or not there's any evidence of that perhaps doesn't matter, but it's pointing the finger, saying that we deliberately overstated the number of licenses at 7CI. But it's clear it came from the IT function. And that's not entirely surprising, because this is right at the beginning or near the beginning of the relationship. And obviously the consultant is placed in there to give advice, as was Owen Connolly. And in fact, it's a contractual term, as we'll see when we get to the MSA, that the consultants advise and the company is exclusively responsible for procurement. So it's a completely misconceived point when they point the finger at Owen Connolly. And he, in his fourth witness statement, says that they were up to their eyeballs in IT people who were all over his recommendations and checking that they were justifiable. But I just thought, since we're at that page, I'd point out that interesting snippet that shows where the information that led to the requirement of 21,000 units came from. And it was the organization itself, not from 7CI. Again, we can see on page 25, it's invoiced quarterly in advance, payment terms 15 days after receipt, all amounts exclusive of VAT and applicable tax. Over the page to 26, this time it's the group CFO, Deepak Sonaji, I think it is, who is mentioned a number of times in depositions, who has signed the contract. So again, a very senior level officer of the company entering into this agreement for a quarterly payment of US dollars 243,569 cents, which can be seen at the top of page 26 on the right-hand side. If I may now go to the Master Services Agreement. This seems to have been signed by Owen Connolly on the 8th of November on page 28. And it's got a date, the 1st of February 24, where there's a signature by the CIO of the defendant. The contract refers at page 35 to being governed by the law of the DIFC and jurisdiction similarly. And then the terms and conditions start at 29. At page 30, at clause 1.22, there's the provision of services that this master service agreement is targeted at. And then at 31, 1.32, customer obligations. Moving down to 1.37, the customer acknowledges that except as otherwise expressly provided in the agreement, it is exclusively responsible to lawfully procure and maintain at its exclusive cost and expense all equipment, devices, software, licenses. So that clearly covers the 21,000 endpoints that were continued to be used, continued to be paid for without complaint until the defendant had no wriggle room and then decided to point the finger after filing a defence firmly at Owen Connolly. But it was their responsibility to procure, and that supports the evidence of Owen Connolly when he says, it wasn't me, I gave advice. It was up to them what they did. Turning over the page to page 32 is the area of the agreement that was flagged up by your lordship, fees and billing. 1.44, the customer may not withhold or set off any payment from any fees due to the provider. 1.45 includes the words, if the customer acting in good faith disputes any portion of a fee that provider invoiced, the customer must nonetheless remit the provider full payment of the undisputed portion in accordance with the provisions of this section, and provider on or before the original due date of the disputed fee a written and reasoned notification of the disputed portion of the fee, laying down in reasonably sufficient detail the grounds for the dispute. In parenthesis, given the dates on all of the invoices in this case, it would rather suggest that in the absence of any written notification of a complaint, all of these sums, every one of them, are due, overdue, they haven't been paid, and are susceptible to immediate judgment in our respectful submission. And then 1.47, customers' failure to settle any overdue fee within 15 calendar days of its original due date specified in the corresponding SO will constitute a material breach of the SO, entitling the provider to exercise the remedies set forth in 11 below.
On its face, Mr. Rainsford, if those two clauses apply to the totality of the invoices rendered, and because this is a master services agreement, one's initial thinking would be that that was the case, you'd be entitled to judgment regardless of any counterclaim, wouldn't you?
Yes, my lord. That is our submission, in our submission, where we are.
Well, I understand that, but the question, if that's right, then yes, you get your judgment, but there might be room for pursuit of a counterclaim should Mr. Frayne-Bell wish to pursue it. I understand you want to persuade me that there's no room for the counterclaim at all because the facts are such that it can't get off the ground.
Yes, and they've had ample time to put this together. I mean, even within the life of the instant proceedings, they've had more than enough time to show that there is some evidential indicia capable of giving rise to a proper evidence-based case. But they obviously can't do it, otherwise they would have done when filing evidence from Paul Francis. Termination, page 33, my lord. 1.561. Terminate any service specified in the respective SO at the end of the service initial service term and during any subsequent renewal period by providing the other party with at least 90 days written notice. The 90 days that, of course, are referred to by the CIDO in the email of the 27th of September 2024. Which shows the entitlement to the 90-day runoff period. And just in parenthesis, in the dialogue between Paul Francis and Owen Connolly, it's actually Owen Connolly in the context of being exasperated that not only can't they pay the sums due, but they can't even promise when they're going to make future payments, is saying, well, maybe you should give notice. You can. The idea that the notice was coming from GFC Alliance is completely flawed. They probably didn't want to, because of course, if the 21,000 endpoints were suddenly no longer available, they'd be at serious risk in the organization from cyber threat. It might take some time to put in place another 21,000 units to cover them. There's then on page 34, limitation of liability at 1.64. It even addresses consequential damage, consequential loss, but it protects 7CI, not the defendant. turning over the page at 35, disputes governing law and court jurisdiction. 1.69 refers to the parties referring any dispute and controversy basically before trying other sorts of dispute resolution. That was clearly done here. There was endless talk about when are you going to pay and giving them extra chance, trying to negotiate on behalf of the defendant more time with the software provider so they didn't withdraw their services. There's 2 letters before claim in this case, and none of it worked. But in any event, 1.70, nothing herein shall in any way affect the rights of the party, basically to litigate the case. 1.71, the agreement is going to be governed by the laws of the DIFC. 1.72, the jurisdiction of the DIFC. So they're the points that I would make on the contracts. My Lord, we adopt all of the evidence of Owen Connolly in his 4 witness statements. The points that he seeks to capture have been made in submissions so far. But I'd ask the court to bear in mind that what Owen Connolly says is actually evidence in this case. What Paul Francis has said is contradicted by documents of a contemporary nature in this case, to the extent that it matters.
Well, he doesn't give a lot of direct evidence in any event, does he, Mr. Francis?
He doesn't, but where he points the finger at Owen Connolly, the preponderance, the overwhelming preponderance of evidence is in favour of Owen Connolly, not the other way around. And in fact, I'd go as far to say that there isn't a jot of actual evidence that carries any weight at all that points the other way. I mean, you've got the opinion of some IT people that isn't independently verified or even tested. That doesn't even appear to fit with the documents in any event and the evidence that is available. And the whistleblower has been sacked. It's quite a big deal to sack a whistleblower. I'm sure I don't need to address your lordship about something like that, but a big corporate wouldn't do it readily because they're protected by statute. Amongst the allegations that Paul Francis has made, misuse of IT funds causing a $4 million loss, mismanagement, purchasing products without proper consultation, that there was no need for Sentinel-1. There's some suggestion that existing software licenses could have been used instead. The answer from Mr. Connolly is, well, you would have had to pay for subscriptions for those to continue, and they would have cost more. That's never been rebutted. The complaint isn't limited to Sentinel-1. There are 4 other products that are attacked by the whistleblower and by the former CIDO. None of them were supplied by 7CI, and yet the corporate had the same problems. Now, one of the suggestions being made by the defendant that there was a delay in implementation. That's misconceived as well, because in the bundle there's correspondence where, in relation to the implementation of the Sentinel software, a supplier of it is chasing Owen Connolly, who then chases the CFO of GFC to get an order. The order comes through, and then the software, which according to the email correspondence, the idea, the project had disappeared into the GFC ether, is suddenly evangelized because the order comes from the CFO and the acquisition of the SF1 material can be made. But the implementation delay wasn't down to 7C. It fits better with Owen Connolly's account that the delay was down to the corporate. The procurement policy itself, there's complaint made that things were acquired without the proper processes being followed. It was down to the corporate to follow their own procurement processes. Owen Connolly was there to advise them on their needs and did so professionally. It was a matter for them to effect any acquisitions, and it's completely misconceived to point the finger of blame at Owen Connolly. Could we look at page 182 of the bundle, please, Val? This is Owen Connolly's second witness statement. Having said that the number of licenses, the 21,000, have been set by the organisation, not by him, at paragraph 15, he says, ultimately, the services offered by the claimant were approved and utilised by the defendant, and whether or not the defendant followed its own internal processes in obtaining them does not stand as a defence for the claimant's entitlement to pay for these services. He goes on at the next page of paragraph 17 to reject at 16.1 the idea that other software could have been used instead. And at 17, he rejects the impropriety that's levelled against him, including conflict of interest. Now that goes to Paul Francis's point that they appear to have been making a profit on this deal. But the contract for Sentinel-1 was between 7CI and the defendant. They knew that Sentinel-1 belonged to a software company and that the defendant was acquiring the software. They marked it up according to the defendant by 10%. That's not a huge markup. But the reason there was a master services agreement and not just the S1 agreement was precisely because they were there to advise the corporate. The corporate acquired the things that it needed. But 7CI were also providing services to the corporate. Everyone knew that. Owen Connolly said, I even specifically flagged up potential conflict of interest. But at the end of the day, it was their decision what to acquire and whether to follow my advice or not. I alluded to evidence that rebuts the suggestion that the delay was at the door of 7CI, and I'd like to flag that up if I may. My lord, please could you look at page 100 and you'll see an email from someone called Daniel Burns to Owen Connolly about Sentinel-1 quote, and it's from the 27th of October 2021. Hi Owen, I hope you're doing well. When you get a moment, could you please let me know how you're doing with Sentinel-1 rollout? And over the page at the bottom is an email on 101 from Owen Connolly, and it's going to Deepak Sagani, who is the Chief Financial Officer of the defendant. Hi both. This is November 29th, 2021. The proposal for Sentinel-1 seems to have disappeared into the ether. We need to get this signed today in order to get the orders lined up and the distributor and Sentinel-1 themselves. If we don't, we will lose the current price point we have which is based on end-of-year discounts. We will also severely impact the rollout for UK Steel and InfraBuild, which will result in an existing, more expansive solution being renewed for another year. Thanks for your cooperation. And on the back of that, an order was forthcoming from the corporate, from CFO, and Sentinel-1 came belt. But there'd obviously been a significant delay, but it wasn't 7CI causing it. The other thing about 101 is it shows that this was being rolled out in the UK at UK Steel from Dubai, which is another indicator that this wasn't a rollout that was confined just to Dubai. My lord, the actual invoices, the outstanding amounts due on them, the pleaded sum is 3,403,756 dirhams. The interest as at the 30th of June 2025 is another 202,579 AED, making a total of 3606335. And then there's the amount due for early termination, which is 773,640, the pleaded sum. The interest as at the 30th of June, AED 19,077, 19077, making a total of 792,717. Further damages, the two constituent parts of that were the court fee when 7CI was sued because they couldn't afford to pay the bills for those 21,000 licenses, together with modest legal cost totaling 87,219 AED, and the total claimed on that is 87,219. May I briefly address the court on that aspect, the damages claim?
Yes, I have difficulty with that, Mr. Wainsford.
I may have more of an uphill struggle with that than any of the rest.
I think you may. Yes.
May I at least outline the way that we would put it?
Yes.
The Law of Damages and Remedies, Law number 7 of 2005. Please forgive me because I doubt for one moment that this isn't something that your lordship already knows about. Part 2, damages under Law of Contract. 12, foreseeability of harm. No. Clause 10 under Part 2 deals with measure of damages, and B is any loss, including incidental or consequential loss caused by breach. Less C, any cost or other loss that the injured party has avoided by not having to perform. And then 12, foreseeability of harm. The non-performing party is liable only for loss which it foresaw or could reasonably have foreseen at the time of its non-performance as being likely to result therein. Now, in a nutshell, first of all of the contracts were predicated on payment in advance, and a big corporate with very grown-up directors, such as their CFO and the big chief himself, would fully appreciate the need for cash flow for a much smaller entity when acquiring endpoints on this magnitude, this scale, and when putting in consultants for significant periods of time. Secondly, when they started breaching and failing to pay, they were continually chased And within the body of the WhatsApp chat, it's very clear that they're being told that 7CI are on their knees. These are large sums of money, and they need the money to pay their supplier Sentinel. And that they even discuss that they're going to become insolvent if the defendant doesn't pay up. But as I said, it wasn't won't pay, it was can't pay. So they drip fed them money, but not enough. And there came a point when a payment structure, which is in the bundle, was proposed and accepted, and the payment structure was taken to the supplier of the software, who agreed to abide by it. And if we could look at page 62 in the bundle, it's the Appendix B that we started with right at the very beginning of the hearing, 2nd of July. And it's addressed to Paul, who's Paul Francis, the president of the defendant. Hi, Paul. So when we last met to discuss the outstanding Sentinel-1 payments, you proposed the below payment structure. We in turn took this to our supplier in good faith, and they accepted it. It's now the 2nd of July, and we've seen no sign of payment of the first $255,000. I'll just pausing there in parenthesis and go to page 65, the letter before claim. Paragraph 3 of Alfredian Angle's letter. We are also instructed that despite Liberty Steel having agreed a payment plan of 7CI as recently as the 31st of May, Liberty Steel has failed to honour its commitments and continues to withhold payment to 7CI. As well as the substantial harm that is caused directly to 7CI, Liberty Steel failure to honour its contractual commitments has upset 7CI's relationships with key software vendors, which in turn has eroded substantial goodwill and eventually resulted in them issuing a claim against the claimant because they couldn't pay for the licenses in the absence of being paid in advance or even on time by the defendant. And this is why we respectfully submit that it was foreseeable, this loss. It was very clearly flagged up. So even if they didn't understand the commercial imperative of being paid in advance, they certainly knew by the time the WhatsApp chat was going on and these meetings were going on that 7CI were in trouble and needed the money. So we submit that it was foreseeable and not remote. Now, either I'm going to be able to persuade your lordship or not about remoteness, and I accept that your lordship probably knows way more about this than I do. I've flagged up the way that we put our case, and I hope in the light of the explanation given, your lordship will give due consideration to whether or not we can fall within part 2 of Law number 7 of 2005.
The point I need to put to you is this, Mr. Rainsford. In the ordinary way, when there is failure to pay a debt, interest is awarded by the court on the debt, and the reason for that is always said to be that the court works on the basis that you can always borrow the money, and therefore what you get is compensation for being out of your money for that period. I'd always understood, I think I was probably brought up many years ago as a young lawyer to say that you didn't get damages for breach of a contract to pay money. The law doesn't appear to be saying that anymore as such. And English law, if you look in Chitty, really doesn't sort of comment on the point very much. But are there actually any authorities that directly deal with this?
I haven't found one on the point. The answer to the conundrum I would respectfully submit is the door is clearly open if your lordship wanted to make the order and thought that it was just to do so. And one reason why it may be appropriate is because these were such large sums owed by a major corporate over a very long period of time, when they were being told this is causing us real trouble, it's putting us in real jeopardy, and they still didn't pay the bills, and they knew what was likely to happen, and they let it happen.
At the end of the day, I'm sure Mr. Rain Bell will say, well, I understand all that you're saying, but the claimant was able to pay the money to Sentinel. They entered into a settlement that was effectively for the total sum without any interest.
They did pay, but it's pretty clear from the evidence available in the bundle that it put them in real difficulty.
Yeah.
And caused them a great deal of stress.
Yes, well, more important than the stress is the fact they had to pay some costs.
Yes. Yeah.
There is a slight oddity, isn't there, about the court fees? I mean, as I read the settlement agreement, it said that each side was going to pay its own fees, and you wonder, but therefore, why they finished up paying the Sentinel court fee. I understand they'd pay their own court fees on filing documents, but why did they finish up paying Sentinel's court fees?
Because the legal costs were their own lawyers' fees.
Yeah, but it does say specifically. It says specifically the court. I'm sorry. It does say specifically in the evidence the court fee payable by Sentinel.
It does, and in fact, Mr. Prainbell has flagged that point up as well.
If it was their own court fees, I would understand them being out of pocket on it.
Well, they paid their own court fees, is what I'm being instructed by WhatsApp.
Right. Okay.
That would make sense.
Well, of course it would make sense under the system, and everybody pays a fee on filing documents of one kind or another.
Must be the settlement agreement that's got an error in it.
Well, it's not. No, I don't think so. I think it's the evidence that would be an error. And the settlement agreement says each side to pay its own costs. So you would expect the defendant, you as the defendant in that action, to have had to pay your own lawyer's fees and your own court fees.
I'm being instructed no lawyer's fees were paid. We had to pay the supplier's court fees for filing their claim.
Right. Well, that doesn't appear from the settlement agreement.
No, but it's what it says. It's their error. There is an error. Let me explain. I'm sorry about this, but I may as well try and answer the point.
Well, why don't we come back to that in due course, Mr. Rainsford, when you've taken proper instructions?
Yes, my lord. Thank you.
Is there anything else you want to say at this stage?
May I just check with my instructing lawyers in Dubai? They can hear the question.
Yes.
Have I missed anything that you would like me to flag up? Is my question to my instructing lawyers. Nothing for now.
Very good.
Thank you, my lord.
All right. Mr. Prainbell, where do you want to start, so to speak, in relation to applications and that sort of thing?
Thank you, my lord. My lord, dealing firstly with applications, I wonder, I'm being inclined to agree with my lord in relation to what my lord said right at the outset, that the most effective way of proceeding at the moment is to deal with the evidence and assume for the sake of argument that the defence and counterclaim effectively represent the evidence as far as we're concerned from Paul Francis, which is PF1 at page 130 onwards. And what I was going to do by way of opening now is to just deal with what I thought one of the key issues that had arisen during my learned friend's discussion with my lord, and that is the question of set-off, which was raised right at the outset by my lord in relation to the MSA contract. And I thought it would be perhaps helpful to start with that, because my lord is quite right that in certain circumstances, of course, that could be the end of it in a discussion such as this. What I would say, however, if I may, is just in response to what you had been discussing with my learned friend, I wonder if we could perhaps just start page 46 of the bundle. Forgive me if I've got the wrong reference, but yes, I have. I'm so sorry. It wasn't page 46 that I should be looking at. That wasn't a very good start at all. If we could go to page 29, please, that I am confident. Yes. So if we just go from page 29 initially to the pertinent point. So fees and billing is, I'm going to say page 32. Yes, fees and billing is page 32. So reading short, we look at very briefly paragraph 144, which is the paragraph that we've been looking at, that in effect, we wouldn't be entitled to withhold any payment of any fees that were due to provider under this contract. And that's pretty clear. And allied to that, there's obviously the definition of fees. And if we just briefly go to, I think it should be page 29. Yes, page 29 in the definition section at 1.6. Again, reading short for the purposes of what I wanted to say, that fees means any and all payments and charges due to the provider in connection with this MSA. And that is the point, my lord, that the invoices in relation to the MSA, we say would exclude the S1 or the Sentinel matters. And if regard is had to pull Francis's first witness statement, and we look, which starts at page 130 of the bundle. I don't intend to laboriously go through Mr. Francis's statement, because I mean my lord has had an opportunity to read it, and but it's clear from the way that it is set out that there are effectively, as far as the defendant is concerned, more than one claim, and more importantly, more than one contract. And as my learned friend has quite helpfully set out, there are effectively three contracts. There's the COD contract as it's defined, the Sentinel contract, and then the MSA. And focusing on the MSA point, if we go down in Paul Francis's witness statement, and if we go down to, I think it's paragraph, apologies, I should have this here, paragraph 40 onwards, well, perhaps going to 38, because there's the heading. Our Lord will see that it's not in dispute that the defendant terminated the MSA on the 27th of September 2024. And thereafter, there is a discussion between the parties resolving as Mr. Francis says, resolving the amount of money that should be paid under the MSA, and at paragraph 41, reference is made to the claimant agreeing to forbear from the payment of dirhams 257,880, and the defendant would pay 105,000, etc. So the reason I make reference to that section of the of Mr. Francis' evidence is it's clear in my submission that the counterclaim, which is based upon the oversupply, if I could just colloquially use that word, the oversupply of the Sentinel 1 units, is different from the MSA, and that the point that I wish to make is that the MSA, in effect, does not cover all of the dispute. It's dated the 1st of February 2024, and as my lord will see from the evidence of Paul Francis, that at paragraph 23, the dispute in relation to the endpoint usage of Sentinel-1 goes back to usage in 2021 and 2022, and therefore well before the coming into force of the MSA contract. So I think what my point would be in relation to the MSA is that, yes, on the face of it, there is a set-off clause, which is very clear in relation to fees due under the MSA contract as defined in the said contract. And also it's clear that there were discussions in relation to the fees due, if you like, under the MSA contract after its termination. But what I would say, my lord, is that that contract does not govern, as I see it, all of the sums that would fall due for the reasons that are set out by Mr. Francis. And indeed, as my lord has pointed out, that the defendant isn't prevented from its counterclaim. However, I think it's of note that the MSA contract comes into creation some considerable time after the issues with the Sentinel-1 handsets. The second thing, allied to...
Can I just stop you there for a moment?
Yes, of course, sorry. Yes.
This is a, quote, master services agreement.
It is.
And if you go back to clause 1.19, 1.20, and so on, it's plainly intended to be something that governs all the dealings between the parties, at least from that date onwards. So I take your point about your counterclaim going back to 2021, 22, 2023. But in relation to the claim that's being made against you, it all postdates the MSA, doesn't it?
In terms of that element of the claim that postdates the MSA, that is the reference to yes, and hence the discussion between Paul Francis, which he sorry, I'm not doing very well with my page numbering, which he sets out in his witness statement, paragraph 40 onwards, that notwithstanding what is said in the MSA, that if we go to paragraph 130, sorry, page 130, and back to paragraph 40.
Yeah.
Sorry. Yes.
I've got paragraph 40.
Yes, we'll see set out what in effect happens after the termination of the MSA, and that there appears to have been as Mr. Francis says, a new agreement in relation to the future, paragraph 41, and therefore dealing with the 773,000 termination claim, that has been, if you like, by agreement between the parties, reduced considerably.
What am I expected to make? What am I expected to make of that, Mr. Frayne-Bell? Mr. Francis wasn't present at any of the meetings. He simply recites that there were such meetings attended by other people. I've got no evidence from Mr. Chaturvedi, who apparently is left under a cloud. I've got no evidence from Mr. Thomas, the claimant CEO, on that case. There's no documentary support for this of any kind. And I have evidence from Mr. Connolly that this isn't right. So what do I do about it?
Well, my lord, we are where we are in the sense that Mr. Francis has set out his position. He is, my lord, of course, a senior figure in the organization. He is the president of GFG Alliance, so that I think it's safe to say that someone of that standing would have carried out their own due diligence of what had happened before committing it to a witness statement. But my lord, I accept my lord's point that the defendant's position is set out by Mr. Francis, and that there are no allied or ancillary statements from others who were allegedly at those meetings.
I have a real difficulty, Mr. Frayne, but looking at Mr. Francis's witness statement. There's the standard paragraph, in his case, paragraph 2. The facts set out in this witness statement are derived from my own knowledge and are true. Where any facts or matters are not within my knowledge, I've stated the source of information. I confirm they're true to the best of my knowledge and belief. And then you simply get to paragraph 40, where he makes assertions. He doesn't say that he's been, as far as I can see, that this is information he's obtained from Mr. Chaturvedi, who was present. He doesn't give a source of the information. He just makes the assertion.
Yes, I can't. I mean, I've no reason to believe that it's an assertion based upon what he believes to be true. But I accept what my lord says, that it's expressed as it is, my lord, and all I can say is that Mr. Francis, as a senior executive, has expressed a position which he believes to be true. But I do accept what my lord says. I wonder if just before we move on, if I could perhaps just, I can't imagine there'll be any difficulty if on instruction by WhatsApp, that the reference to Mr. Chaturvedi, Nikhil Chaturvedi, who my lord has heard has left the company, as I understand, that he has left the organization, that's Liberty, to take a senior role with another large global organization. And at this stage, it was felt impractical or not appropriate to get a witness statement from him just at the moment, but he is around, so to speak. But I pass that on. But I take my lord's point. The position of the defendants has been set out in my submission clearly by a senior official in the organization, and it is not supported by others at this point. But I would say to my lord, on the other side of that coin, is that the lack of support shouldn't automatically lead to this evidence being, dare I say, doubted at face value.
Well, I have to take account of it, is what you say.
Indeed, and I would invite my lord to take account of it. And I accept that my learned friend has additional evidence that were this matter to go to trial, he would rely upon. Were this matter to go to trial and the defendants were both able to defend the claim and also present a counterclaim, then of course there would be further evidence and witness statements as there would in any trial, and there would doubtless be further disclosure, etc. But I accept that for the purposes of today's hearing, which is an application for immediate judgment, that the court is entitled, which hence my Lord's comments right at the start, entitled, putting it this way, to sort of, I suppose, bypass the pleadings and look to see what evidence there is available at the time of an immediate judgment application, or certainly it's a relevant component to the court's decision making. But I would say, notwithstanding that, there is in Mr. Francis's detailed first witness statement an explanation as to why there is a dispute with the claimant. And of course, that dispute is based materially in part on the report, the IT report, a report which is, as I understand, produced by the internal audit team. And it is a report which is referred to in his first witness statement. And this is a report which was compiled having interviewed a number of people within the IT team. And indeed, the report, and I think it's referred to as a note, is exhibited to his first witness statement. And it is, accept the fact that it is marked as a draft report, but my Lord will see from looking at it that notwithstanding the word draft, it is a detailed report. And that report is what started the investigation, well, which formed a material part of the investigation into the alleged mismanagement of the IT services. And that has led to the submitting of the counterclaim in relation to the excess amounts of the Sentinel handsets or end user points, which totals, as far as the defendant says, sum of in excess of about 4 million, I beg your pardon, in excess of about 7 million dirhams. So the test for today is there a realistic or fanciful prospect of the defendant being able to defend the claim that is made against it? And if the answer to that is yes, then we would then turn to the question of the amended defences. And if my Lord finds that even looking at the evidence that the claim remains, supposed to use the word from the authorities, fanciful, then the claimant would be on that basis would succeed in its claim. The key issue in my submission, my Lord, is that the second witness statement of Paul Francis deals with, of course, the second key issue, which is the question of delay. And Mr. Francis sets out in that witness statement, which starts at page 643 of the bundle, that in effect, in terms, that there was a desire to, if you like, maintain the status quo as much as possible, but there was, when the time came to it and it was clear that there was going to be no amicable resolution, a claim was filed, and the defendant's position, based upon what is seen in the IT report, is such as that they have a claim against the claimant for mismanagement of the services that were provided, to use that general expression. It may well be that the determination of today comes down to my Lord's view in relation to set-off claim in the MSA agreement. However, I would say that it is clear that, albeit it is on the word of Mr. Francis, that, if I can put it like this, the parties had got beyond that after the termination of the MSA agreement. The key question, therefore, is, does the evidence point to a tribal issue which would have realistic prospects of success? And when I say the evidence, I'm talking, as far as we're concerned, about the first witness statement of Paul Francis, when measured against the evidence that is presented by the claimant and has been set out by my learned friend. And it's a fairly established test, and the decision which my learned friend refers to in his skeleton, realistic over fanciful, represents really the established parameters in a hearing of this nature. There's probably not very much more, my lord, that I can add. I'm very happy to do so, but I think I would summarize by saying that the position of the defendant, clearly set out by Paul Francis in my submission, would indicate clearly that there is a defense to this claim leading to a counterclaim which would have realistic prospects of success, notwithstanding what has been said by the claimant. And I'd invite my lord to consider Mr. Francis's evidence, and of course what's said in the draft defense, etc. But we can come on to that if it becomes relevant in due course. At this stage, focusing on the evidence, we rely on what Paul Francis says, and of course, my lord, that an integral part of his witness statement is the report, which is referred to as the IT report. And if we could perhaps, if I could perhaps just finish with that, and if my lord would allow me just one moment to go back to the statement, and if we look at paragraph 17 and 18, and I'm slowing up my speech deliberately because I'm hoping that those instructing me will give me the bundle reference number for the IT report, which I failed to write down.
153?
I have it, my lord. It's 153. Thank you. And 153, my lord, it's an 18-page report. My lord will see very briefly that on page 3, which is at 155, the allegations and the background are set out. My lord will see from the tables there's reference to the 21,000 units for Sentinel-1, the fact that only 5,000, 9,000 and 15,000, etc. were used, as is reflected in the pleadings. My lord will see that there is a specific reference for example on, now this is page, say, 164. There is specific reference at paragraph heading 4, 164, products purchased without assessment of competitor products and price benchmarking. That's a matter which is raised in the pleadings and again by Mr. Francis. There is reference to numerous instances, as the defendant will say, of management issues and service provision issues by the claimant. And so whilst Mr. Francis is the only person to present a witness statement. Contained within that witness statement is this internal audit report dated the 29th of May 2024, which, as he says, is based upon interviews with key personnel involved in the IT provision. And if my Lord looks just briefly at page 156, it sets out paragraph 1 that the internal audit team was able to interview and carry out discussions and consider emails, which are set out at A, B, C, and D thereunder, including obtaining inputs from Mr. Chaturvedi, who I referred to a few moments ago. So well, what I would like to perhaps add, my Lord, is that it's not just Mr. Francis speaking here. He does refer to this detailed report. Yes, I accept it's marked as a draft report, but it's quite clear that significant work has gone into investigating these allegations, and that they haven't been raised in pleadings to date. Mr. Francis explains why that is the case in his second witness statement. But as far as his first witness statement is concerned, the evidence, available evidence of this report is, in my submission, of material importance to any consideration of an immediate judgment order one way or the other. That's probably as far as I can take it, my Lord, in terms of the evidence. We would rely on what is said by Paul Francis, and that if the defendant was in a position to amend its defence and add a counterclaim, the evidence of Paul Francis would be material to the contents of both of those exercises. I'm going to ask, if I may, if there's any those instructing me would like me to add. And whilst I'm just asking that question, and for them thinking about it, I wonder if, my Lord, if there's anything I could assist further with.
The damages claim, Mr. Frayne-Bell.
Yes.
That the result of your failure to pay, your client's failure to pay, it is said that that had the result that the claimant couldn't pay Sentinel. Sentinel then issued proceedings, and they settled the proceedings, and what they claim from you is essentially the cost that they've incurred in doing that, plus the rather oddity of the court fees paid by the claimant, by the claimant in that action. What do you say about the general principles that I should take into account in that context?
In terms of the general principles, my Lord, my view, and it may be wrong and outdated, but as far as a non-payment action is concerned, the attendant inconvenience, hassle, and commercial difficulties that may be caused would ordinarily be covered by interest, which is why ordinarily the interest rates are reasonably generous if interest is being awarded by a court. So that's my general response. As far as this claim is concerned, I'm just going to go to, if I may, I'm just going to remind myself of that section on damages, and I'm sorry for slight delay. Yes. Well, in response to that, I'm looking at page 142 of the bundle, which is paragraph 43 onwards of Mr. Francis's first witness statement, dealing with the further damages of, just rounding them up, 54,000 dirhams, plus 9,000 odd dirhams for the legal costs. I'm looking at paragraph number 48 and 49 as well. So I think based on that, I'm sorry, I know I'm not being particularly of assistance, but I think in relation to that, it's quite clear that it wasn't intended or expected that there would be in the future a claim of this nature, given what was agreed as set out, paragraph 48 of Mr. Francis's statement. I don't think there's other than what is said there, my lord. I don't think that I would wish to say anything further, and I would simply rely upon my general position of interest. But I accept, of course, that this relates to arguably another document, but certainly the defendant's position is that they would not accept the further damages claim. And the final thing, if I may, which I would wish to conclude on, is that in my submission, it's clear from the fact that there is competing evidence between the two parties that there is, in my submission, there are clearly matters that are suitable for trial, and the evidence shows that there are tribal issues. The mere fact that there is particular disagreements across the board is illustrative of that. So I think I would simply conclude on that point, and unless I can be of any further assistance at this stage. This is obviously focusing upon the evidence which is available to my lord that we've looked at. I don't think that I have anything further to add on this discrete point.
Yes. If you were to look at the law of damages and remedies, which I was taken to earlier by Mr. Rainsford.
Yes.
I don't know if you have that to hand or if it's even in the bundle.
My lord, if I don't, but is it in the bundle? Because if it is, I've got the bundle here, but it may not be.
It's not.
No, I think it isn't. But
I'm very happy to have it. I'm happy to listen.
Well, it's beyond my capability to share the document with you, I'm afraid, particularly in the circumstances. But damages under the law of contract, part 2, talks about full compensation for loss sustained as a result of non-performance. And then it talks about the measure, including incidental or consequential loss caused by the breach. It talks about reasonable degree of certainty. And then you get in 17, clause 17, interest for failure to pay money. if a party doesn't pay a sum of money when it falls due, the aggrieved party is entitled to interest upon that sum from the time when payment is due to the time of payment, whether or not the non-payment is excused. And it tells you then about the rate of interest. And then it says, subject to the foreseeability standard of Article 12, the aggrieved party is entitled to additional damages if the non-payment caused it a greater loss. The aggrieved party is entitled to additional damages if the non-payment caused it a greater loss. It seems to be a complete repeat, but that is, as I understand it, the position in the DIFC, which is to that extent different from the UK.
Yes.
Because it does specifically envisage additional damages if there's greater loss than interest.
If it was foreseeable.
It's got to be foreseeable, and it's got to satisfy the test of reasonable degree of certainty. But if you know that the party to whom you owe money has cash flow difficulties and perhaps even is potentially on the verge of insolvency, and of course one knows that people say these things in an effort to procure payment of money, but if there is knowledge of that, then it is indeed foreseeable, is it not, that there could be litigation which would lead to greater cost?
I don't think I could argue with that.
Well, I think that's the relevant provision. So unless anybody's going to direct me to anything other than Article 17.3 of the Law of Damages, that seems to me the test that I need to apply.
Yes, I don't think I'd take issue with that test, and it's a matter for my lord whether, when considering the facts, that test would be met. And certainly, I think, as my learned friend indicated, it's a fairly broadly worded provision.
Now, the last point I need to ask you about, and indeed I shall ask Mr. Rainsford about, is supposing I took the view that the anti-set-off clause was the complete answer to the claim for summary judgment, what would be the difference between my dealing with the counterclaim and saying no point in that continuing? It's well, I'm sorry, what would be the difference between requiring you to start again with a fresh claim and allowing the counterclaim to go ahead? This is assuming that I think it's arguable. Take that hypothesis.
Yes. So there are, if I could try and address that specific point as quickly as I can, there are 3 contracts. One of them is the MSA.
Yeah.
There is a claim for 4.2 million dirhams. The MSA covers the set-off provisions there would cover any fees that fall specifically under that. And there are, of course, as Mr. Francis has set out, and again, well, there's a position which is set out clearly by Mr. Francis that the parties had in effect moved on from what the MSA had said, and they were, and that as set out, and another deal had been arranged. But to answer your question, it would, in my submission, my lord, if I could put it like this, it would really depend on the numbers. So, for example, if just say the MSA agreement equates to, say, $1 million dirhams worth of the claim, and I picked that number entirely out of my head, then there would still be a claim for, say, 3 million dirhams, which would not be privy to any set-off provisions. And on that basis, that claim could continue, and therefore could continue with a counterclaim seeking to counterclaim against a balance. I'm just using the figure of 3 million for this for the sake of ease, so that it would depend, therefore, in my view, the sum that would equate to the MSA against the total claim value.
I think what at cost purposes.
Sorry, I apologize if we are.
Not at all. I think it was, I didn't put the point,
Sorry.
the question very clearly. Assume for the moment that I'm against you in relation to the claim for judgment against you.
Yes.
On the basis that the anti-set-off clause is sufficient to deal with the claims that are made against you, all of which post-date the date of the MSA, even the invoice which was originally rendered earlier and which your clients say didn't arrive until sometime in September 2024.
That's right.
So just assume I'm against you on all of that and judgment is going to be entered against you. The question then is, in the context of your application for permission to amend to plead a counterclaim, why should I allow that at this late stage rather than simply leaving you to pursue a fresh claim in relation to all the matters that you say you're entitled to as a result of Mr. Francis and the IT reports and so
on? If my lord was of the view in relation to set-off, I can't imagine any basis upon which my lord would allow the counterclaim to remain in play in the way that the application has been made by the defendant.
Well, I'm slightly surprised to hear you say that, Mr. Freyenbell. I thought you would probably say that, well, you're entitled to pursue your counterclaim. It's in the same action. You don't want to have to pay a fresh fee to start new proceedings.
Well, if there's no claim, if the claim is a zero, then I mean the counterclaim hasn't been allowed in yet.
No, that's my question to you. I mean, it seems to me that if I'm against you on the question of judgment, but I was to think that the counterclaim was not so thin that I could simply dismiss it and saying it wasn't worth anything at all, then the question would be, why should I allow it to continue in this action, or should I say, well, you've come along much too late with this information and this and so on, and I'm going to not give you permission to amend, and you can start again in a fresh written claim if you wish to do so.
Well, if my lord was going to make an order for immediate judgment in terms of, speaking hypothetically, in terms of the claim,
yeah,
then on that basis, the claimant has, in effect, been successful in its claim, and the counterclaim which is being proposed is a counterclaim which is being proposed in the current action. And if my lord was willing to allow the current action to continue, notwithstanding the finding that there should be immediate judgment because of the set-off provisions, then the advantage, of course, to the defendant is that it means that there isn't a requirement for starting all over again on exactly the same basis as they would be proceeding on the counterclaim. So if my lord is willing to do that, yeah, and yes, if that would be much more that would be a very practical approach if my lord is willing to consider that, albeit there would be, in that scenario, there would have been a finding of there would have been an immediate judgment finding against the claimant, beg your pardon, against the defendant. So perhaps I can start again as I'm sort of
think of it in these terms, Mr.
Yes.
Freinwell. Think of the classic cases where you have anti-sent-off clauses, or the effect in law is that there is no room for a set-off. So there's a claim on a check, for example.
Yes.
And along comes the signatory of the check, and he says, yes, but the goods were deficient. And the court says, well, that's very interesting. The goods are deficient. You say that's the case, but I'm going to give judgment on the check. And if you wish to pursue your claim for deficient goods, then okay, that's a matter for you. But you carry on and do that in. Usually, it would be done by way of counterclaim in the same action, having held that it was no defence, but there was a basis for a counterclaim. So I would have expected you to be saying that was an analogous position here, if I took the view that I said I might in relation to the anti-set-off clause.
Yes, well, I do take on board
the real point against you on that, the real point against you that you have to deal with is that you turn up very, very late with this counterclaim, and therefore, why should I give permission to amend at all? If I don't give permission to amend, then you have to go off and start again, and you have to pay your further fee and all the rest of it.
Yes,
I'm conscious of the well-known financial difficulties of the GFG group. I say they're well publicised, and so the question arises in that context.
Yes, well, thanks, my lord. Having reflected on what my lord is saying, I think perhaps my initial position is predicated on the fact that there is no counterclaim as matters stand, but I think that on reflection, what my position would be in my lord's hypothetical scenario is that in the event that the court was to grant immediate judgment to the claimant for the claim value or whatever amount the court was to determine, on that basis, the defendant would then maintain its application to amend its, putting it this way, amend its defense by introducing a counterclaim, to introduce a counterclaim, and continue with that application, notwithstanding any immediate judgment order that was made, and that would enable the defendant, if that application was successful and was, as my lord has indicated, could still be considered, notwithstanding any immediate judgment order, that would enable the defendant to proceed with its counterclaim, which would be based upon the evidence of Mr. Francis and the draft counterclaim that has been produced. The question that follows immediately after that, if I may turn to it immediately, is why, as my lord has posited, why would the court do that when it comes at the 11th hour? And I would, on that basis, I would answer that question, if it was going to be asked, by referring the court to Mr. Francis' second witness statement, where he sets out why it comes so late. And I take on board, if I may, the point that, and it is clearly within judicial knowledge, and in fact, there has been considerable international news press about, if I can just call it, the Liberty Group in general, and that if my lord was willing, again in this hypothetical situation, was willing to still consider the application to allow a counterclaim in the same action, then of course that would have a that would lead to the saving of time and expense in having to refile a brand new application, given that in either scenario the claimant is really in the same position, whether or not it's a counterclaim under the present action or whether or not it is a fresh claim based upon what Mr. Francis has set out in his evidence and what my lord will have seen in the draft of the defence of the counterclaim. And I wonder, my lord, if I could perhaps just I think if I may add, my lord, as well, that what we're discussing here is, of course, a hypothetical scenario in relation to a immediate judgment order being made based upon the set-off clause within that judgment. The concern that those instructing me have is that it's clear from what Mr. Francis has said in his evidence that there clearly have been discussions in relation to that MSA agreement and in relation to monies that may or may not be owed under it, and that because of that, that is a matter which would require to be considered at trial and before any finding was made as to whether or not, in fact, the set-off provision in this particular circumstances of this case should be applied, as opposed to it being applied on a summary basis without any evidence.
I've got that point.
Thank you. And I'm reminded that, as my lord will be fully aware as well, that under DIFC law, and I don't think this is necessarily different from anywhere else, that an ambiguous contract ought to be interpreted against the party who drafted it. But I think that that's not really in the same ballpark. So, my lord, I hope that answers all of my lord's questions. And I'm sorry if I slightly overwhelmed everybody with discourse in response to what are probably fairly straightforward questions. But I think in general, it's not just quite as straightforward as it seems, my lord. This is a case where there's clearly there are clearly contrary evidential positions. There is a clear discussion that's set up by Mr. Francis about the MSA, and that the parties appear to have moved away from it, and indeed may have structured another contract, and that's something that really, in my view, would require further evidence and further consideration about in a trial. But I'm veering off a bit from my lord's question. Which I hope I've answered.
Yes, thank you very much, Mr. Frainbell.
I don't think there's anything else that I'm being asked to raise. No.
Right, thank you very much.
Thank you, my lord.
Mr. Rainsford, can I ask you just direct me to that passage that deals with the date of receipt of the invoice under the COD?
It's the 20th of September, and it's in Paul Francis's first witness statement, I think.
Right. I think it was in the pleading, the original pleading.
Yes, my reference from, which is actually from my memory, is that it's in Paul Francis's first witness statement, which is
Right.
at page 130 onwards.
Yeah.
Yeah. Give me just one moment.
Is that
Yes, it's paragraph 7 of the original defence.
Very well, thank you.
Produced a document with invoice number 2022-02 for a total sum of 252,000 AED. Claimant didn't provide this invoice until the 20th September 2024 in the context of a reconciliation of the parties' ledgers. Yeah. So just to be clear, as I read the particulars of claim at paragraph 10, each of the invoices postdates the MSA, save for the very first, which it is said was in fact sent on the 20th of September 2024, and indeed there's no direct evidence to the contrary, as part of the reconciliation of accounts.
Yes. Of course, it was never challenged in any way.
No, I've got that point.
They did. Yeah. Sorry.
The point at issue being, as it seems to me, uncontrovertible position that the MSA applies to the submission of all invoices.
Yeah.
And in those that context, there therefore can be no defence to this claim.
I respectfully agree.
So I don't require you to address me on the question of defence. What does arise, however, is the cost claim. And you've made submissions already as to why you say that there's nothing in it and that the application for permission to amend is made too late. But is there anything further that you want to say in response to anything that Mr. Frayne-Bell has said, or should I treat your submissions as being concluded?
May I be very brief, because there are a few points that I'd like to raise. First of all, contrary to what your lordship has said, we respectfully submit that no fee has been paid on the counterclaim.
Right.
And if I could just go through that, Article 2B of the CFI proceedings at B deals with counterclaim. The court fee payable by a defendant is based on the value of the counterclaim and is calculated per the schedule above in relation to Part 7 claims. It says counterclaim. For a claim made by way of counterclaim, the same fee shall be payable as if the relief or remedy sought were subject to separate proceedings. But no fee has been paid, so it makes no difference to Liberty whether leave is given at this stage or not.
Oh, I see. Because they've only sought permission to amend at this stage.
Yes.
I've got you. Yeah.
And in any event, it is not only terribly late, but the entire attitude of the defendant has been fairly transparent for everyone to see. That they've buried their heads in the sand. There was a 10-week delay during which they could have engaged. They chose not to do so. When they corresponded with the court, they didn't say that they were going to raise a counterclaim. They said that they were going to answer with evidence the matters that had been raised. in Mr. Francis's evidence, he didn't see fit to point out that the whistleblower had been dismissed, which, given the status of this IT review, the draft review, at the heart of their counterclaim, some may think lacks a certain amount of candor in failing to flag up the fact that the whistleblower was dismissed, and not mentioning that the CIDO had also left, apparently under a cloud, which one might have expected Mr. Francis to flag up, but he chose not to do so. Nor did he say that he had the WhatsApp messages, which undermine completely the core of his evidence about why they wished to counterclaim and why they didn't pay the invoices at the material time. He then says that there was delay because he hoped to settle. But may I draw attention to page 665, please, my lord, which is the fourth witness statement of Owen Connolly. At paragraph 9 onwards, under purported attempts to settle, he flags up Mr. Francis's reference to constructive negotiations at paragraph 9. He then at 10 says there were no negotiations with the defendant since the filing of PF1 on the 28th of May. The defendant repeatedly failed to make payments due to the claimant. No negotiations involved discussions relating to purported counterclaims or the quality of services provided, as is clear from the evidence set out in my second witness statement. They came way too late and way underprepared if one were to take seriously this counterclaim. But may I please invite your lordship to look at page 156 of the IT report, the draft report referred to by my learned friend, Mr. Frayne Bell.
Yes.
Under the synopsis, which appears at the top left-hand side, it refers at A to a review of limited documentary evidence provided by the employees. The employees are 4 in number. 2 of them have never been named. One of them is Mr. Nikhil Chaturvedi, who has left under a cloud. He only survived for about a year and was new in post at the time when this report was drafted. He says, it says in the report, they performed at C public domain searches on employees and vendors. It says at D, they obtained input from Nikhil Chaturvedi, who is the new CIDO. And then in the column under amounts, look at the size of these amounts. It's been leveled against 7CI that licenses for new products were purchased without consulting regional IT teams. Amount $5 million. 2 licenses for new products and solutions. $1.7 million. 4, another $5 million. If this was a serious concern, these matters would have been properly investigated by external lawyers or accountants. A proper signed review and an update would have been prepared for the court. Evidence would have been put before the court about the essence of what they found. But they didn't even do what they said they were going to do in this report. If we turn over the page at 157, under 3, CIDO's inputs, the IA discussed the allegations on the 9th of May. It says 2023, it must be 24. And then over the page, synopsis. Way forward, to conclusively prove the issues highlighted above, it would be important to conduct the following additional steps. And then 1 and 2 are not terribly interesting, but 3 would be to interview the alleged persons. Owen, the first named, he was never interviewed. These allegations were never raised with him. This report is now over a year old. And if they were going to take these allegations seriously, they would certainly have wanted to interview him by now. But what did they do? They left him in post until December 24. Could I please refer to the costs of the legal claim, the point that your lordship raised? At page 117 of the bundle, the first page is the application by Intertech against 7CI for judgment. Second page shows what was payable by way of legal costs. Court fees, 35% now, $8,964.
Where are you?
This is on 117. It's the second page of the claim filed in the DIFC by Intertech Systems against 7CI. And we can see that the court fee paid was 8,964.
Yes.
Now, the settlement agreement at page 120 shows what each person agreed. And the only thing that had to be paid by the defendant was the court fee of $8,964 by the claimant in this case. That is what they lost. And obviously there was their legal fees as well. And having reviewed the 2005 law number 7 and the provisions that your lordship flagged up at 17, 16 was mitigating loss. The claimant did everything they could to do that. Foreseeability, well, it would seem that it was foreseeable. Measure of damages, B and C, includes incidental or consequential loss as a result of the breach and costs incurred by the injured party. We respectfully submit that the entire claim, all of it made in this case, should appropriately be the subject of immediate judgment. Unless I can assist the court any further, those are our brief submissions in response to my learned friend's submissions.
Okay. Just to pick you up on the settlement agreement.
Yes, my lord.
Page 120, I think.
Yes, clause 1, I think it is.
Yeah, so they paid 2,093,823.51.
Yes. Clause 8 says each party settles its own legal costs. That's on 122.
Yes. So why isn't Intertech paying its own court fee? I mean, on the face of it, you're claiming that you've paid the 8,964.10, which was payable by Intertech under this agreement. And
I understand that we paid it to them. The settlement amount is the claim plus Intertech's court fee. That is how we get there.
Yes. All right. Well, there we go.
My lord, I'm sorry to interrupt. I wonder if I might be allowed just to clarify one point, or perhaps even seek clarification on one point, just in relation to something that has been discussed with my learned friend. I'll be very brief, if that would be acceptable.
Yes.
Thank you. My lord, just in relation, it could be perhaps go to page 6 of the bundle, which is the particulars of claim.
Yeah.
In the particulars of claim, which we looked at just a few moments ago, under the heading defendants failed to pay in further damages, which is page 2 of the document, so bottom of page 5 of the bundle, then on to page 6, my lord will see that the claimants have set out that at the time of the particulars of claim and the claim being issued, that there were a number of invoices which were unpaid. In fact, 7. And these 7 invoices, if we put the dates to one side for a moment of when they were invoiced, but these invoices were split up between the 3 contracts, the COD agreement, the SI agreement, and the MSA agreement. Now, in relation to all of these invoices, and albeit there's some disparity about the first one, but for the sake of argument, all of these invoices are issued after the entering into of the MSA on the 1st of February of 2024. The MSA which we looked at in terms of billing, etc., and I looked at very briefly at page 29 of the bundle. The MSA, my lord, makes clear that the fees that would be subject to any set-off provisions contained within this document, the fees here mean any fees in connection with this MSA. Now, I accept that the dates of these invoices are post all of the invoices say post date the 1st of February 2024, but it is clear, my lord, in my submission that as far as the claimant's own case is concerned, that these invoices related to work done under different contracts, including the MSA. And again, I just wanted to reiterate the point that I made earlier, that it's far from clear that all of these invoices would come under the MSA, notwithstanding the dates of the invoices, and secondly, that there are 3 contracts, and therefore the result of that, the attendant result of that, is far from clear whether any of the fee notes, sorry, I beg your pardon, whether any of the invoices which relate to the other contracts would fall within this MSA contract, notwithstanding the date of the invoices. And that, my lord, again, is another example of a matter which there is dispute about potentially, and would benefit from full consideration as opposed to summary consideration. And I'm grateful for the opportunity just to make that, just to reaffirm that point.
I'd got that point, Mr. Frainburn, in fact. Thank you very much.
Thank you.
All right. Sorry. I shall give judgment for the claimants in respect of everything other than the court fee, which I don't understand as being payable under the settlement agreement. But in every other respect, I consider that the claimant is entitled to judgment. I will set out in writing my reasons for that, which are based on 2 essential points. The first is the anti-sent-off provision, whether it applies to all the invoices or only to certain of them. But secondly, to the absence, it seems to me, of any defence that has a realistic prospect of success. I shall, in that context, refuse permission to amend the defence to include the counterclaim, which is brought much too late, and given the fact it has, in my view, no realistic prospects of success, whether by way of defence or counterclaim, will therefore not be allowed. If the defendants think they have good grounds for these complaints, which have never been pursued despite the IT report, which in itself appears to me to be inconclusive on its face, and plainly has not been pursued with a concluded view that there is any liability on the claimants. If the defendants wish to take out, file a new claim, well, that's a matter for them. But there will be judgment for the claimant. I suppose that means I need to deal with costs today, does it? Do I have schedules of costs and that
Yes,
sort
there is a schedule, my lord. There was also a Part 32 offer, and the award exceeds the sum that we offered to settle at.
Right. All right. So as a matter of interest, what did you offer to settle at?
3.403755. So AED 3,403,755.
And what have I just awarded you?
Excuse me, just 1 second, my lord. Just need to find my table that I was looking at earlier.
Well, it's about four. It's about
46.
Yes.
Four and a bit, isn't it?
46.
Yes,
401.
Yeah. All right. Well,
it's
in principle,
yeah, it's over 4.2 million.
In principle, you're obviously entitled to your costs. I don't suppose Mr. Frayne Bell will contend for anything else. So
No,
it's a matter of looking at the schedule and making a summary assessment, is it?
Would you please do that, my lord? Yes, it's all set out in detail in the schedule.
Yes. Where will I find the schedule?
As far as I know, it's been submitted to the registry. Under Rule 38, of course, conduct is relevant, or may be relevant to costs, and I'm being asked whether your lordship would consider an indemnity costs order, given the way this litigation has been largely conducted by the defendant ignoring the proceedings and doing everything very late, and also in particular putting forward a defence that really had no merit at all.
I'm afraid I don't regard putting forward a defence that has no merit as being sufficiently out of the norm to justify indemnity costs. It's one of those things that happens. So it'll be costs on the standard basis. So let me just look and see if I've got a schedule of costs somewhere.
I'm just going to check with my instructing solicitors that this is with the registry. I'm pretty sure it is.
I have it. Yeah.
It's not in the bundle though.
No, we wouldn't have put it in the bundle. It would seem presumptuous to do that. It's filed though. It's with the court.
I don't doubt that, but I don't think it's reached me as yet. Let me just check. No, I don't have a schedule, though the court will. Two options: either I ask the court to send it to me straight away, and we can now try and deal with it, or alternatively, we could deal with it on paper. I'd rather prefer to deal with it today, if at all possible.
Yes, please.
Lena, do you have a cost schedule that you can send to me by email?
Yes, Your Honor, I just sent it.
Oh, thank you very much.
Of course, thank you.
It still hasn't arrived. Ah.
But while we're waiting for that, my lord, may I just, I'm receiving instructions. Rule 32.51 Subject to Rule 32.54, where Rule 32.492 applies, the court will, unless it considers unjust to do so, order that the claimant is entitled to interest on the whole or part of any sum of money, excluding interest, awarded at a rate not exceeding 10% above base rate, for some or all of the period, starting with the date of which the relevant period expired. 2, his costs on the indemnity basis from the date on which the relevant period expired. And 3, interest on those costs at a rate of 10% above base rate. Indemnity from the date Part 32 expired. I've read those provisions to your lordship and ask that they be taken into account if you think it's appropriate, my lord.
Right. So we're now looking at the part 32, are we?
Yes. I'll need to open the rules up on my laptop.
Right. Well, I'm.
If your lordship's got comments.
Rule 32.
Yes, I'm sorry. When I was talking about indemnity costs, I was talking in terms of not in relation to the Part 32 offer, but in relation to the generality of conduct outside the norm, so to speak. But now you're directing me to Part 32. Can you just take me through the bits you rely on there again?
Yes, my lord. Subject to Rule 32.54, this is 32.51.51. Where Rule 32.492 applies, the court will, unless it considers unjust to do so, order that the claimant is entitled to 1, interest on the whole or part of any sum of money, excluding interest, awarded at a rate of not exceeding 10% above base rate for some or all of the period, starting with the date on which the relevant period expired. 2, his costs on the indemnity basis for the date from the date on which the relevant period expired. And 3, interest on those costs at a rate of not exceeding 10% above base rate. Indemnity from the date Part 32 expired, and that was the 29th of May.
Right. Well, I don't think I have any details of your Part 32 offer as to when it was made.
I'll just pull up the letter now. The letter's the 8th of May, my lord. And
just give me the figure. I think you will need to send a copy of this letter to the court, because I don't have it.
Could I ask my instructing solicitors who can hear this to do that right away, please? Could I
just tell me what the figure was again?
AED 3,403,755.
Yeah. And
it's 21 days from that, which is the 29th of May, when the relevant period expired.
That's what I was looking for. Thank you.
The Part 32 is being sent through right now to the court.
Yes. But needless to say, your schedule of costs doesn't identify those costs incurred since the 29th of May?
No, I wonder if there's someone
Well, it's not entirely surprising, because schedules are limited in that way. We don't ask for a full schedule that sets out each and every entry.
There's nowhere to put it in the cost form.
No, of course there isn't.
No.
But let's just look at the totals first of all, and then I'll ask Mr. Frayne Bell if he has points he wants to address in relation to it.
My solicitors are offering to provide the information if required.
So
maybe we should see what happens today and whether or not they're content to leave it at whatever order is made today.
So we've got a total in dollars of 165,000 odd, right?
My lord. That's the grand total, yes.
Yeah. Mr. Frayne Bell, first of all, there's the question of indemnity costs, which arise under Part 32, as opposed to the court's general jurisdiction. So you may want to address me on that. And then secondly, the question of quantum of costs.
Yes.
I haven't seen your schedule, whether you put in a schedule, so I don't know how the figures compared with what you would have claimed had you succeeded.
My lord, I wonder if I could do it in reverse. I have taken instructions. If we deal just with the schedule of costs as it is, as a schedule of costs, no issue is taken with the total of the costs.
Right. Okay. Well, that's
subject, of course, to anything that my lord might consider. Yes. So that deals with that. In relation to the Part 32 offer, I have to confess, I haven't seen it either. However, what I would say is that
well, it doesn't really matter if it doesn't matter if you're not taking issue. No. If you're not taking issue with the total figure, that's fine. I can simply make an award of that figure, and that resolves the problem.
Well, my lord, just so I can be clear here, I understand that the 165,000 doesn't include, or maybe I've misunderstood that, doesn't include any separate uplift in relation to Part 32, or have I got that wrong?
That's right.
So, as I understand it, there is another calculation which is being requested, which is related to the proportion of those costs incurred after the 29th of May.
Well, I haven't seen any claim for that at all. I was simply assuming this was the total, and in the ordinary way, if one was making an award of costs, one would probably knock something off on the basis that standard costs, you rarely get the lot. So
yes, well,
if you're happy with the figure, then that's fine.
Well, I think what I would say, my lord, is that we have no submissions to make in relation to it being unreasonable, and that ultimately the matter is for the court to determine what the final figures are. Just to be clear on my position.
Yes.
I'm sorry.
Yeah. No, I understand your position entirely. I've looked at the figures. I'm entirely happy with the hourly rates and the time spent, and I do not consider those figures to be unreasonable. And regardless, therefore, of any indemnity costs from the 29th of May onwards, I'm happy to award the figure of 165,485 by way of costs.
Thank you, my lord. It may very well just stay there. I don't anticipate we'll be coming back with a request for more.
No, well, I think you can't. It's too late.
Very well. Thank you.
Too late to come back for more. So far as the figures are concerned, can you draw up the necessary order for agreement? It will be, as I say, for all the sums that you claim, except for the court fee.
So that would include the $10,000 of legal advice that had to be paid for.
Yes, you get everything in relation to the costs of that litigation that you claim, except for the court fee that was, in my judgment, something which was to be paid by Intertek under the settlement agreement. But if you can produce a draft order, I will draft some reasons, and we'll put together the order, and you'll get it back in a day or two's time.
And what about the rate of interest, my lord?
The rate of interest on, first of all, the rate of interest on the judgment sum. What are you claiming for there?
I'm sure I'll be corrected if it's out of order, but I think 10% is probably appropriate.
Well, I think that is out of order, because you would get the 10% from the 29th of May onwards, isn't that right?
Yes.
Whereas before that, you would get a much more standard rate.
I'll be guided by your lordship. I've seen judgments with 9% in the DIFC.
Yeah, well, it does sometimes happen. Mr. Framebell, do you have any submissions on the rate of interest?
My lord, my view would be less than 10% for 29th of May, and the figure that comes to mind is 8%. But I leave it to my lord's discretion and experience.
Well, what I've got no evidence as to the cost of borrowing on the part of the claimant. But the essential principle is that you would ordinarily get an interest rate that corresponded to your to what you have to pay if you borrow money. Have you got any instructions on that, Mr. Rainsford?
I was hoping I'd receive some. It may come through any second now. Someone's typing something, so I'm hoping it's about to arrive. Oh, it simply said we're okay. Forgive me.
You've given me figures which include interest up to the 30th of June.
Right.
Right?
Yes.
So the answer is surely to give to proceed on that basis, and then fix an interest rate in respect of the period post 30th of June, which on this basis would entitle you to a 10% figure.
The practice direction number 4 of 2017, the rate was 1% over the IBOR rate, EIBOR.
Yeah.
The solicitors are saying that they're okay with the 8% that was suggested by my learned friend.
But what have you put in your interest calculations up to the 30th of June?
I have no information about interest after the 30th of June.
No, before
it's being suggested 5%.
I'm sorry.
It was put 5%.
That up to the 30th of June. The
yes,
figures you gave
that's
me.
Right, my lord.
Right.
Yes.
Okay. Well, I think the answer is to take a broad view of it and take your figures up to the 30th of June as being accurate. And then from the 30th of June onwards, you can have interest on the principal sums at 10% and interest on the cost you can have from the from today's date at 10%.
Thank you, my lord.
Until payment. Are you clear about that and can produce a draft to the court?
Yes, my lord.
Having passed it by Mr. Frayne Bell, obviously, for his approval or disapproval.
Yes, we'll get right on to it.
I say, if you can pass it by
need...
one another and see if you can agree the figures on the principles that I've just suggested, and then I will produce. We'll produce an order in due course.
We'll aim to get this to your lordship in a few hours' time, or less.
Very good. All right. Anything else then that I need to deal with?
I'm just receiving a message. May I ask the court's indulgence just for 1 second while I see what it is? Oh, yes. I don't know. No, it's a personal message. Thank you.
All right. Very good. Well, if you'd all like to sign out, I'm very grateful to counsel for their assistance on both sides. And I will talk to the associate if you would be kind enough to go. Thank you very much.
Thank you for reading the